I want to take you to this. A major legal bombshell from the Constitutional Court has sent shockwaves through thousands of South African households. In a landmark judgment delivered just days ago, the Apex Court has ruled that antenuptial contracts signed after a customary marriage is concluded are legally invalid, even if they were signed before a subsequent civil ceremony. This judgment reinforces the principle that the financial consequences of a marriage are fixed at the time of its solemnization, preventing couples from unilaterally changing their status from in community of property to out of community of property without a formal court-sanctioned application. Legal experts are calling this a significant victory for legal certainty, but a potential financial shock, for couples who believed their later signed antenuptial contracts were valid. For more on this, we're joined by Prof. Anthony Diale, Director of the Center for Legal Integration in Africa at the University of the Western Cape. Prof, good afternoon. Thank you so much for your time. Really do appreciate it. Very basically, what is the jurisprudence implication of this judgment?
The implication is that there is no double marriage in South Africa. So there used to be a tendency in the past to think that if you contract a customary law marriage followed by a civil law marriage, and then you would have two separate marriages. But that court judgment reaffirms that there is only one marriage, one continuous marriage, meaning that if you marry under customary law and then marry under civil law, the civil law marriage will swallow or replace the customary law marriage. And this, the key implication is that whatever contract you signed before the customary law marriage, it is binding unless you take out what we call a post-nuptial contract by approaching a court to vary that arrangement.
Yeah, so just for clarity, this does not invalidate post-nuptial processes. That is to say, the ability to change your wedding contract or wedding arrangement after the fact of your customary or civil marriage. That is still possible. It just is a separate process. I'm understanding you correctly.
Right. So what the implication of this means in practice is that you can change your marriage system, but you cannot change it. The parties cannot change it among themselves. They must approach a court. They must provide good reasons why they need to change. And then they must satisfy the court that creditors or other third parties are not affected. Then and only then can they change their marriage system. But it's not an antenuptial contract like people think. In other words, it's not something that happens before a marriage, but it's something that happens after a marriage, because the customary law marriage is regarded as one marriage that survives, even though it is swallowed or replaced by the civil law marriage, but it continues as one continuous marriage.
Yeah. Now let's talk about what constitutes a valid customary marriage. What are the sufficient conditions in a customary marriage for it to constitute as a valid marriage?
For a customary law marriage to qualify as valid under the law, the parties must be up to 18 years of age. If they are not up to 18 years of age, they must obtain the consent of their parents or the consent of the minister. That's number one. Number two, they must agree, of course, to be married. And then the third most important requirement is that the marriage must be celebrated in accordance with customary law. Note that the Recognition of Customary Marriages Act does not demand that payment of lobola or bride wealth is a requirement. But by saying that the marriage must be conducted in accordance with customary law, it indirectly brings in the payment of bride wealth, because it's something that is a custom in most African communities, almost all African communities.
Yeah, and that was going to be my next question, because customs differ from culture to culture, right? Different cultures have different practices around how they conceptualize their customs. For instance, in some instances, a full payment of lobola is required for it to be considered a valid marriage per the custom of that culture. And in some, you don't need a full payment of lobola for it to be considered a valid marriage, or for you to be considered husband and wife, whatever the case may be. How does the court interpret those differences in certain customs?
Well, the court adopts an approach we call cultural pluralism approach, by allowing communities to have variances. So what the court normally does is to make sure that whatever practice that the community is engaging in complies with constitutional values of equality, human dignity, and freedom from discrimination. So once these are satisfied, then the court is prepared to go with whatever the community is going with, so long as it's their customary law. So the court is not prescriptive in that regard, as far as the requirements of a valid customary law marriage are concerned.
Yeah, and so you mentioned earlier that there must be a celebration. Is there any specificity, or is the case law clear on what a celebration looks like?
Well, the case law is not that clear. I think it varies from community to community. So long as there is sufficient evidence before the court that both families consented to the marriage and that there was some sort of public announcement, public ceremony in whatever form, then the courts are satisfied that the customary law marriage took place. In fact, in a couple of cases, the judges have even held that although the bride was not formally handed over to the father of the groom or to the head of his family, that there is still a customary law marriage in place. So the court is not too
Yeah.
prescriptive as to what constitutes ceremony.
I want to ask you about an instance where, for instance, two families meet. They are there to negotiate lobola. There's an anticipation that it would be agreed upon, and once it's agreed upon, a portion thereof would be paid over, it would be celebrated, and that constitutes a marriage. Now, that is the ordinary case, which in many instances, that is what people practice. But in an instance where the families meet, they don't meet each other on the terms of the marriage. They don't agree to the lobola. In fact, they don't agree to the procedures. Maybe it's two different cultures that are engaged here. And so they first have to find each other on that. But they nonetheless, as two separate families, decide to have lunch in celebration and be joyous and merry at the end of the day, despite the fact that they didn't quite agree on anything pertaining to the substance of the marriage. Does that qualify as something that the court would deem to be a celebration of a marriage?
Well, you have to understand one thing. The courts adopt what we call a case-by-case approach, meaning that the circumstances of a particular case will differ from the next case that comes before them. So the courts consider the evidence. If there is evidence, both oral evidence and documentary evidence with pictures, etc., showing that, yes, these people engaged in a ceremony that qualifies as a marriage, then the court is ready to rule that a marriage is in place.
Yeah. And just lastly on that, you mentioned earlier on if a post-nuptial contract or a post-nuptial arrangement to a marriage seeking to change the contract after the fact of the marriage is one that has to be approved by the courts, and the courts there are seeking to safeguard either both parties and or any other third party, including creditors that might be implicated or prejudiced by this test. In what instances do the courts say no to a couple seeking to change the nature of their marriage contract after the fact?
Well, I can think of at least two situations in which the court may refuse to change the marriage system. If the change will unfairly prejudice one of the parties, or if the change will unfairly prejudice a creditor, or if the court finds that there are ulterior motives behind the change of marriage system. For instance, one party is being unnecessarily forced into it, even if it is not apparent, then the court will refuse to change the marriage system. But if the court is satisfied that there are good reasons, sound reasons for the change, then the court is usually willing to agree to let the parties change.
I mean,
so both parties must approach the court jointly, and they must do so freely and willingly with full informed consent.
Yeah. And so what is the advice to those who seek to get married, both customarily and in a civil arrangement, but who want to be married outside community of property? What is your advice to them?
Well, you see, this is a very sensitive issue now. Africans are by Africans, I mean Black Africans are fond of marrying under customary law and then marrying under civil law. My advice would be, don't do it. Don't do it. A customary law marriage is enough. You don't need a civil law marriage. And the reason why I say a customary law marriage is enough is that a customary law marriage now has all the benefits, all of them, all the benefits of a civil law marriage. So the marriage is automatically in community of property, meaning profit and loss 50-50, unless the parties before the marriage agree to take out a contract among themselves. And in that contract, they will specify that their marriage is out of community of property, with or without the accrual system. In other words, whatever the wealth they acquire during the marriage can be excluded or included. So if the parties do this, we call it an antenuptial contract, and then that's fine. They don't need a civil marriage. In fact, my problem with that judgment is that the judges should have laid the ground for parliament, for legislature, to prohibit couples from marrying, from undertaking a civil law marriage after a customary law marriage. It's completely unnecessary. So for parties who wish to marry and take out a contract, do it before the civil law marriage. And then make sure that you register it in the deeds office within 3 months of the contract coming into place. If you fail to do this, any agreement that you want to take afterwards, you must approach the court because it's a post-nuptial contract, no longer an antenuptial contract.
That brings in another point of confusion, because per our customs, we typically get married customarily before we get married in a civil marriage, right? And so if we have, it's almost impossible in many instances to have a antenuptial contract agreed before a customary marriage, because our families have to agree, and that's what the customary process is about, that the families have to agree for us to get married. In the instance that we then sign an antenuptial contract after our families have agreed, what that judgment implies is that, no, your antenuptial contract is invalid. That seems to be in contradiction to what many customs, African customary practices are. Are you receiving it in the same way?
That's a great point you raised there. And that goes all the way back to the question, at which point does a customary law marriage come into place?
Yeah.
I think that if we look at what the law provides, it comes into place when the marriage is celebrated in terms of customary law. But for the purposes of an antenuptial contract, in practical terms, I feel that if you finish the ceremony, you can take out your contract before you register your customary law marriage. That should satisfy the law. But this is perhaps something for me and my colleagues in the Law Reform Commission to consider.
Yeah,
no one has raised this point. At which point? Yeah, it's a very great point to raise. But I think for practical purposes, you can celebrate your marriage, and then before you register it, then you take out your antenuptial contract.
Yeah, we're going to have to leave it there. Thank you so much, Professor Diallo. I really do appreciate your insights this afternoon.